Robert Romanchuk. I'm a trainer based in Winston-Salem, North Carolina. I come to this subject having served in a large community health system as the director of research. So I managed a health system that had, I think it's got more hospitals now, but it had 13 hospitals, about 450 physician practices, and a multi-state footprint. So over that 15-year tenure, I oversaw the creation of a central research office and built systems to manage many of the things we'll be talking about today, specifically clinical trial contract negotiations and Medicare billing and billing systems to make sure that all of the issues we'll be talking about today were appropriately managed. I've presented on this topic in the past at several different venues. Currently, I'm a chair at a central IRB, so my role has changed a little bit, but these issues have not for those that are involved in research operations. So what we're going to do is examine the regulatory restraints that impact clinical trial contracts and budgets, draw the connections to those legal restraints and specific contract and budget terms. And then hopefully it'll become a little bit more practical and clear as we walk through a typical contract and budget and apply each of these regulations to each section of a contract or budget. And then hopefully along the way, you'll see how to develop best practices to maximize revenue and minimize risk in clinical trial negotiations. So hopefully by the end of this session, you should be able to discuss the implications of the Stark Law, the Anti-Kickback Statute, the False Claims Act, and the Medicare Secondary Payer Rule. So obviously these are all U.S. regulations, so these risks are all related to negotiating budgets and contracts in the U.S. Hopefully you'll see how to identify the risk areas and negotiate them safely, and you can create a process that assures that you address these concerns with each negotiation. So the big picture, as you may have already guessed, my perspective on this topic is from the institutional viewpoint. And you'll see that many or most of the rules really impact the site, the institution most of all. But you'll also see that sponsors bear quite a bit of risk, especially in the anti-kickback statute. So all of the parties to clinical trial contract and budget negotiations are on the hook, if you will, and all need to understand these. And it's my contention as well that sponsors may not be directly impacted by some of these regulations. Understanding them helps them negotiate contracts and budgets because they know the pressures that institutions are under from these regulations. So a word about all of the regulations we're talking about today. None of them were put in place originally to address contracts for clinical research or clinical research operations. So they were put in place to catch criminals that are trying to scam the system, if you will, when the government is paying for something. So they weren't devised specifically for clinical research, but they will and they do impact clinical trial contract and budget negotiation process. Another important thing to consider, I'm not a lawyer. As I mentioned earlier, I became aware and proficient on these conversations because in negotiating contracts and budgets, I was responsible to make sure that they were all carefully considered and incorporated in the negotiations. The people steering the conversation and obviously were the compliance officers and the institutional counsel. But in my experience, even institutional counsel and compliance need to pay attention to this specifically because it's a very niche concern, if you will. And they're applying all these regulations we'll be talking about. So I guess where I'm going with that is compliance professionals and even institutional counsel do well to become specifically educated on these facets of the rules that apply to clinical research. And there's a couple good sources like HCCA, Healthcare Compliance Association, that have specific tracks for this kind of, you can get certified in clinical research compliance, which covers all these. And then there are conferences that specifically focus on clinical trial budgets and contracts negotiations and Medicare Secondary Payer Rule. One, for example, is MAGI.